Welcome, everybody. You are listening to Debt Talk Radio, where you learn how to get out of debt the right way. Now, we have a guest today. Now, of course, payofyourdebt.org is all about teaching you techniques, steps, and strategies on how to get out of debt. But there are times that bankruptcy is absolutely needed. And we have a special guest today. His name is Mark Barger. He's a senior partner of Bly, Sheffield, Barger, and Pelletier here in New York. And right now, I just want to welcome him, introduce him to you, and then I'm going to talk to Mark and ask him the frequent questions that come in to payofyourdebt.org, as well as our past podcast. Debt Talk was a podcast show, and now we went to Blog Talk Radio, which I think is just a better format for everyone because we can answer your questions. So stay tuned next week. If you have questions that you would like to ask myself, and we're going to have Mark Barger come back, you can call in. We will have that number provided right at the website, payofyourdebt.org. All you have to do is click on Debt Talk Radio, and all the information will be there available to you. So, welcome, Mark.
Thank you, Tim.
I, first of all, appreciate you coming in, and I have a lot of questions for you, but before I go into that, Mark, give just a background of your firm and your knowledge with bankruptcy, and basically what type of client that comes in and some of the questions that you're getting, a skinny on that. And then, of course, I'm going to ask the questions that are coming in to Debt Talk Radio. So go ahead, introduce yourself and just tell us a little bit about you.
Sure. Well, thank you for having me as a guest today. As you mentioned, I'm the senior partner in Bly, Sheffield, Barger, and Pelletier. We have a general practice firm, but I've spent a lot of the 25 years that I've been practicing assisting people with their debt problems, working with them, and with small businesses, both on non-bankruptcy solutions, and if they needed to file a bankruptcy, working with them and getting them through that process. And I think the thing that I find, that's most people come into a meeting with a lawyer to talk about debt problems, and they are ashamed. They
Yes.
They feel that they failed, and I think one of the first things I try to do is to try to get them to look at it in a different way. And also to let them know that, there's a lot of people that are in their shoes. And, we've worked with people that are in worse situations than they are and successfully helped them through the process. And I think that once they get a sense that I'm not there to scold them, I'm not their father, I'm not going to talk down to them. I remember one client came in one time and had been to see another lawyer, and she said, I left in tears because he made me feel so bad.
We get this all the time.
And I can tell you, and you know this, from my personal experience, my own wife had a business that failed as a result of the economic downturn in 2008, ended up with a substantial amount of debt. So I've been there personally, and that I think is a reason that I can relate to people on the issue of how they feel about this. And the other thing I'll say is, if we're able to find them a solution, be it non-bankruptcy, be it a debt arbitration solution, or if it ends up being a bankruptcy solution, I hear over and over, it's like a weight's been lifted off my shoulders.
Yes.
I can sleep at night now.
Yes.
The phone isn't ringing constantly with creditors harassing me.
Yes.
And when I hear that, then I feel like I've really helped somebody, with their problem.
Awesome. Wonderful. And, I would like to add, this is one of the reasons why my company here locally, we utilize Mark Barger for clients that we can't help, and we refer them to Mark. So I got to, just throw that out there. And one of the reasons why we do that is what you said, that there are some law firms out there that aren't, they just don't seem personable, and I almost think that they they're desensitized. Do you get that sometimes where I think they see so much of it that it's like, you know what, you're just like the last client I saw and I heard the same, story or is similar. And
Yes.
they somehow get desensitized where we never had that with you. And I think for somebody like yourself and mine that have experienced some sort of financial hardship somewhere within our lifetime, that maybe we have we can relate to it, and that's where the empathy comes from.
Yes, I would agree with you. And, look, it's when you deal with a number of people, that we do, the number of people that you deal with, it is easy to fall into that trap of it's the same thing, and why are these people, coming to me, being in the same situation. But I really think that every situation is unique, obviously, but so many of these situations that we see now, especially post 2008, they're not the result of people going out and just going crazy with credit cards and going on vacation and buying toys.
Right.
Somebody's had a major illness.
Yes.
They've lost their job.
Mm-hmm.
I hear over and over, I was able to pay everything until I lost my job. I had this major illness. My husband passed away. My business failed.
Right.
A big one that you and I have seen.
Yes.
Because so many small businesses were making it, but just making it. And all it took was a 20% decrease in their business, a 15% decrease in their business. And
Right.
that was the tipping point to put them over the edge. So I can understand, I suppose, that you can become pretty thick-skinned, but I think you have to look at the clients. These are individuals. These
Yes.
are people.
Mm-hmm.
They have lives. And, our goal is to try to get them back toward, a more normal life, a life that they had maybe before they had all of the debt problems.
Right. Yeah, and that's wonderful because, again, one of the things that we do at payoffyourdebt.org is to help individuals, first of all, find out what options are there for them. That's the biggest thing, because most of my clients, and you may have experienced this as well, that a lot of times that they just kind of like hide their head in the sand because
Yes.
there's this fear thing and they're losing sleep. And I've had clients say they couldn't even eat. I've had clients say it made them eat because of the stress and strain.
Sure. Oh, absolutely.
Possible on their marriage. Matter of fact, I believe it still holds today. The number one reason for divorce is financial. We certainly know that it can put a strain on a marriage. And so we want to help our listeners and viewers with that as well. So here's what you're going to hear today, and this is what we're going to cover today on Blog Debt Talk Radio is, number one, what your options are. And we're, of course, going to cover bankruptcy, and is bankruptcy an option for you? And also, where do you find an attorney? Where do you find an attorney that's going to help you be empathetic to your needs? We're going to help you with that as well. So right now, another thing that I want to point out, if you do have financial problems, especially with credit cards, and you don't know, where you should go to payoffyourdebt.org. We have a lot of information there that's certainly going to point you in the right direction. And we also have services there that will help you, including service providers. So, Mark, I'm going to jump right in and go to the 10 most common questions that are coming into Debt Talk Radio as well as payoffyourdebt.org. And, we're going to try to keep this to 30 minutes. So just, give your best answer on it. And again, if there's additional information that somebody needs, that you can go to payoffyourdebt.org and get it right there. So let's jump in right now. The first question that we have, and it seems like a simple one, but some people really just don't understand or know, and that is, what is a bankruptcy?
Sure.
What is a bankruptcy?
I think it's a great question. A bankruptcy is, first of all, bankruptcy is a federal law, and the bankruptcy laws have been around for well over 100 years. So bankruptcy is not new.
Right.
Bankruptcy existed back in the 20s. Bankruptcy existed, for a long period of time. It's always been a federal law.
Okay.
There are
Define a federal law, meaning state by state.
No, being actually one that Congress passed.
Okay.
So
Every state follows the same rule?
every state follows the federal bankruptcy law and rules. However, there are state-specific exemptions, which are classes of property that you can keep in a bankruptcy. So that is very state-specific. But the bankruptcy law provides for a procedure whereby individuals, businesses can either eliminate their debts or in some cases pay their debts under court supervision. It provides a mechanism for creditors to make claims, but it also has protections in place for creditors not being able to come in and unfairly, if you will, take assets or property from somebody. So it's overseen by a bankruptcy court, and there are several types of bankruptcy. It's probably one of your questions that you've got.
Yes.
And if you want, I can speak to that.
Yes, go ahead. Actually, cover that one.
What you'll hear people talk about straight bankruptcy or liquidation bankruptcy, and what they're really talking about there is what's called a Chapter 7 bankruptcy, and the chapter is just the chapter of the bankruptcy code that this section is under, and that's where that comes from. A Chapter 7 bankruptcy essentially is a bankruptcy where you will be able to, it's called discharging or eliminating all of your unsecured, like credit card debt.
Right.
It does not eliminate secured debt, like a car loan where the car has been put up as collateral, like a home mortgage. That you're going to have to continue to pay. Taxes, for example, are not eliminated in a Chapter 7. So you can see that certain people with certain debt and certain situations are going to fit into that Chapter 7 box. There's also a Chapter 13, which is the other bankruptcy that individuals would be looking at. That is, again, through court monitored and court approved. It is a way of paying off a portion of that unsecured debt and paying some of the secured debt and taxes over a period of time. And the creditors are basically forced to accept that repayment plan. So, for example, if you owe unpaid real estate taxes and you're about to be foreclosed by the municipality for not paying those, you can file a Chapter 13 and potentially stretch the repayment of those unpaid taxes for up to 5 years.
Wow.
Instead of having to come up with the money in 30 days, you can stretch that over 5 years.
Isn't that something?
So, but again, you can see that it would be a particular individual with a particular debt structure and situation that might fit better into a 13, or maybe the 7 is a better fit. There's also Chapter 11, which is corporate reorganizations that are very complicated. There's actually a chapter of the bankruptcy code for farms, Chapter 12. Very rarely used, but it exists.
Okay. I'll be darned. It was really good that you talked about the property tax thing, because just recently there was an auction here in our county, and every state is and every county is pretty much different. Some are the same, some are different. But here, they have a redemption period, and then they have an auction if it's not paid by that. And I know in our state, if the tax, correct me if I'm wrong, I think it's 3 years, and what they do is they force you to pay the most current first.
Absolutely. So you can't just go in and dribble away
Yes.
and keep the tax foreclosure away by paying the oldest. Oh no, you're absolutely right. If you give them $1, they'll apply that dollar to the most current tax.
Isn't that something?
So, it's as an aside, I think that's a huge discouragement to people who have fallen behind on their taxes.
So to summarize what you were saying, so a Chapter 13 could possibly help somebody in that aspect.
Yes.
To now be able to allow them more time to pay those 2 years that they couldn't apply that money to.
We have filed Chapter 13s for people whose sole debt is unpaid real estate taxes.
I'll be darned. Okay. Very, very good. This is the type of information that people need because they just don't know. And I think that it's great that we're helping with our viewership understand, what the rights are. The very first thing that someone needs to do, and I think you would agree with me, is make a plan.
Yes.
You can't hide your head in the sand anymore. Let's make a plan because all that's happening is it's manifesting inside you and making you more nervous and what have you if you can make a plan. So the first thing that they need to do is understand what options are available.
Exactly.
Including bankruptcy.
Yes, and I was going to point out how good it is that you said that and that, to go to payoffyourdebt.org and understand that there are options. People come to see me and they think they have either no options or their only option is, I've got to file a bankruptcy. And as we talk and I understand and learn about their situation, many times they have option. In fact, one option, and it sounds crazy, but one option sometimes is to do nothing at this time.
You're absolutely
because
right.
They're in a situation where creditors really can't do anything to them.
Right. Judgment proof.
They're judgment proof. But another option is I send them to Tim Town.
Right.
Because they have a situation where they can probably do some debt arbitration with your help and to get out of the situation without ever having to file a bankruptcy. But it is so important that they go to payoffyourdebt.org and they look at and learn and try to understand that there are options out there.
Absolutely. I appreciate that.
That is really the first crucial thing because that's what I'm going to go over with them if they come to see me first. Here they've got a great way to do it, in the privacy of their own house by logging on and going to the website. So
absolutely. And it's there for them and it's free.
Can't
be free.
Absolutely.
We certainly want to help with that. So we have a little bit of understanding on the Chapter 7, and I have, here's a good one. And here's a question that says, will I lose everything when I file a personal bankruptcy?
It's a great question. People think that they are going to lose everything. Let's go back to that concept of exemptions that I mentioned before.
Okay.
Every state in their laws have exemptions which apply not only to a bankruptcy, but to any creditor trying to get at your assets. So, in other words, every state has said there are certain things that a person owns that we are going to not let a creditor take. Okay. Certain basic things. Now, it varies state to state.
Yes.
New York State has some exemptions that are, frankly, archaic. They're way out of date. New York State recently, within the past couple of years, changed one of the exemptions, which has made a bigger impact in allowing people actually to file a bankruptcy than any change in the bankruptcy law in 2005, which, of course, was not really designed to let more people file.
Right.
It was designed to let fewer people file, and it really hasn't had that effect, at least in our area. But here's the thing. New York State, the exemption for your house, where you live, your residence, used to be $50,000 per person.
Okay.
It's now been increased so that it's $75,000.
I'll be darned. Wow.
That has created opportunities for people to file a bankruptcy who had a lot of equity in their house.
Wow.
But and so they were over the exemption amount and they couldn't file because then they would have had to give up their house. But to get back to the basic question, so there's all these categories of exemptions, and I'll just give you some more New York State examples. New York State says each person can have a car with equity of $4,000 or less. That's the difference between what you owe and what the car is worth. So it's not a $4,000 car unless you don't owe anything on it. But if you have a $15,000 car and you owe $11,000 on it, you have $4,000 in equity.
Right.
You can keep that car.
Now, if they have no loan against it?
If they have no loan against it, then they're not going to be able to keep that $15,000 car.
What if the car is worth $4,000 or less?
If the car is worth $4,000 or less, they get to keep it.
Okay. Wow.
So, and of course, if there's a loan against it, the bankruptcy is not going to wipe out the loan. They're going to have to keep making the loan payments, but they get to keep the car.
Gotcha.
So that's the trade-off. And there's exemptions for tools of the trade. IRAs and 401ks are exempt. People don't realize that.
No, they don't.
They think if I file a bankruptcy, I'm going to lose my 401k.
Right.
Absolutely not.
Right.
Absolutely not. Now, New York also, within the past couple of years, New York used to say, look, if you file a bankruptcy, you have to use the New York exemptions in the bankruptcy.
Right.
Okay? New York, a couple of years ago, allows you now to use either the New York or there's a set of federal exemptions. And the federal exemptions have what's called a wild card, which, depending on how much equity you have in the house, you may be able to exempt up to almost $12,000 worth of anything, including cash.
Wow. Okay.
And that has been a huge change, at least as far as bankruptcies filed in New York, because and you can also say you have a $6,000 car. The federal exemption is $3,450.
Right.
So here I got a $6,000 car, and I'm $2,550 over the exemption amount. If I have a wild card exemption, I can take the $3,450 car exemption, and the balance I can put in the wild card and keep the car.
Wow. Okay.
And so it's opened up all kinds of possibilities. Again, it's made it possible for people to file who would not have been able to file before.
I'll be darned. Very good. Well, you know, that's a good point, and I think even myself, when we had customers that called us, that was their first fear is we're going to lose everything, and it's good to know that there's laws that protect certain assets. And let me ask you this, and I've heard of this, and I don't know the actual answer. I've heard that some people maybe are going to lose an asset, such as a vehicle or a trailer or something like that. And I've heard where they can actually buy it back from the company. Is that true? Or
they may be able to buy it back from the trustee, yes. Because let's talk about what a bankruptcy trustee is. A bankruptcy trustee is an employee of the Justice Department.
Okay, this is good.
Their job is to administer the bankruptcy. They oversee it. In a Chapter 7, the trustee, when you file a bankruptcy, the legal fiction, if you will, is when you file a bankruptcy, anything you own that is not exempt becomes the property of the bankruptcy estate and essentially becomes subject to the control of the trustee. So let's say you've got that $6,000 car and you file a bankruptcy in New York. It's a $4,000 exemption. You are $2,000 over. Okay. It very well may be possible to go to the trustee and say, you know, I'll give you, make an offer. I'll give you $1,200 or $1,400 to keep my car. Because here's what the trustee would do with that vehicle. Okay. He would try to sell it, which may be extremely difficult, especially when you're talking just one asset. And he's going to have expenses in selling it. Mm-hmm. And so he's not going to get $6,000. He might get $5,500. And there's going to be whatever expenses of sale.
Right.
And so he very well may be willing, or she, depending on, willing to cut a deal with you. And what does he do with that money that he gets? That money gets divided pro rata among your creditors. Mm. And let's say that you don't buy it back from him and he sells your $6,000 car. You're going to get $4,000 because there's an exemption. And so he's going to end up with 2 less expenses. And let's say you have 30 creditors and he's going to divide it among 30 creditors pro rata. They're each going to get $10. So it's depending on the asset, depending on the value, that may be possible.
Oh, okay.
Now, a lot of people who are in a Chapter 7 bankruptcy don't have $1,200 or $1,400 laying around.
Yes.
But maybe they can borrow it from a relative or, somehow.
And they allow that, correct?
Yes. Actually, okay. I mean, because it's not, it's not their own money. If they're getting it from somebody else, then, you certainly can do that. And my experience has been that if somebody is buying an asset back from the trustee generally doesn't ask where the money's coming from.
I'll be darned. That is great information. I'm actually learning something here today.
Well, that's good.
That's really good. Okay, we have time for one more question. And then I just want to reiterate to our viewers that next week we're going to go live. If you want to tune in, we will have the date and time posted at payoffyourdebt.org. All you would have to do is look for the link that says Debt Talk Radio. That is what you're listening to right now. And you can call in your own questions and actually speak to Mark or myself on anything that you would like to speak about, as long as it's dealing with debt. And we'll go from there. And the last question is, the phone rings. The last question is, when do I get, this is a good one, and I'm thinking most of the viewers right now are going to want an answer to this question, because I get it a lot myself. When do I get relief from the creditor harassment? The phone calls coming in.
It's a great question. The simple answer is the relief comes in the form of what's called an automatic stay, which is a fancy term for a federal bankruptcy court order that says the creditors cannot continue to collect on the debt. That comes after you file the bankruptcy petition.
Okay.
And once the creditors receive notice of the filing. That notice is sent by the court by mail, regular good old snail mail.
Yes.
Once a creditor has noticed that you have filed a bankruptcy, they are not allowed to continue to collect on the debt. They can't write you, call you, sue you. If they do, they're in violation of that federal court order, and I'm telling you that if it's a knowing violation, the bankruptcy court takes that extremely seriously.
Okay.
Just like violation of any other court order. It's a serious matter. Now, typically you're looking at a period of several weeks in getting a bankruptcy attorney the necessary paperwork and information, and then all that has to be inputted into a computer program because they're all filed electronically now.
Okay.
So, and there's updating of information, and there's pay stubs that have to be submitted. So there's a lot of information. 80% of the work in a bankruptcy case is up front, prior to filing.
Oh, wow. Okay.
But once that bankruptcy is electronically filed, it gets a case number, and the court within a day mails out those notices. And once the creditors get those notices, that automatic stay is in effect, and that's where your relief comes.
Okay, so just saying I hired Mark Barger is not enough.
No.
It must go through.
And I'll tell you, the creditors, because we tell clients, look, the creditor calls, tell them you're going to file a bankruptcy, give them my name and phone number.
Okay.
Now, what is the two questions that the creditors ask when they call me. Number one, are you retained?
Oh, okay.
Because people come in and talk to me all the time and don't retain me.
Right, doesn't mean anything.
Absolutely.
Right?
The second question they ask is, do you have a case number?
Okay.
And if we don't, what I usually tell them is, and here's some insider secrets.
Wonderful.
I tell them, you know what, we've been retained. We're going to file a Chapter 7 or a Chapter 13, whatever the case may be. Call me back in 30 or 45 days, and I should have a case number for you.
Oh.
Many times, the client will never hear from them again.
I'll be darned.
Because
wow, that's really good to know.
Some people, and you know this, some people get so nervous, they just give the creditor, I'm going to file a bankruptcy, and I'm going to hire Mark Barger to do it.
Right.
And the creditor calls me, and
you don't know that.
I don't know who the person is.
Right.
So, but if they call and I say, yes, we're retained, it is our client, we are going to file it, we're in process, they know it takes some time, call me back.
Now, could your customer service say that as well, or do they have to speak to you? Like your receptionist or whatever.
Right. There are times that they do talk to my assistant who works with me on the bankruptcies, but here's another difference that we have in our office that I've noticed with other offices. I personally work on your case. You meet with me. You don't meet with a staff person.
Right.
You
Wonderful.
don't meet with somebody who's just, I mean, sure, if you're going to drop off some information, you may meet with a staff.
Right.
But your initial meeting is going to be with me. Subsequent meetings are going to be with me. When you come in to sign the bankruptcy, it's going to be with me. I go with you to the meeting of creditors where you appear before the trustee.
Wonderful.
So, I don't delegate that because there's just too many bits of information that what my assistant might not be aware of. Mm-hmm. And so I've just found that I don't want to be caught, with a meeting with a trustee and not know something.
Right.
Or have something pop up that, that I'm totally unaware of.
Okay. Awesome. Mark, it's been a pleasure.
It's been great.
It's been
Thanks for having
informative. Everyone that's listening, Mark is going to be back next week. We'll have a time for you. And we will have that published on payoffyourdebt.org. All you have to do is click on the button up at the top that says Debt Talk Radio. And again, my name is Tim Town, your host, and we will see you next week. Thank you again for watching.